What's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And I know my face is giant on the stream right now. That's just because I don't have the document pulled up. I'm getting it right now. And then I'll switch over. So what is up, guys? Let's see. Here we go. Let me switch over to that guy. There we are. So, I was probably skipping for you because there were some bitrate issues right at the beginning. But, guys, today has been a wacky day. A wacky day for rights. A wacky day for cuckery. You need some eyeliner. Not going to catch me putting makeup on for this stream. All right, guys. So, I've got a short... I wasn't going to do a live stream, but then it kind of, like, someone thought I was going to do a live stream. So here I am. Here I am. That's the outcome that we've got. This is important stuff that has been going on with Cody Wilson. If you remember a couple weeks ago, I talked about, I think 2 weeks ago, something like that. I talked about Cody Wilson. He is the guy who is at the center of the 3D printed, undetectable, automatic murder, one-shot kill, golden ghost guns, printable by every 4-year-old who has access to an inkjet printer at their local school so that they can murder all their classmates. That is what has happened. If you don't know, that is basically the argument of the attorneys general of 21 states. Guys, there are 21 giant idiots out there right now who are violating their ethical responsibilities by lying in a document to the court. They're violating their oaths to uphold the Constitution by having a prior restraint on constitutionally protected speech, and they're doing it in a surreptitious and disgusting manner, and they should probably all be impeached and maybe hanged. The hanging is a little bit of a stretch. Hanged in effigy, where we can all make fun of the piñatas that are shaped like them and beat them until candy comes out. I think that's a plan. Is that a plan? Can we do that? If anyone wants to make effigies of the attorneys general and bring them to Atlanta, we can have a piñata party. Okay. So, small rant aside, here's what happened. The New Jersey Attorney General, alongside, I don't even know who else, another Attorney General, they filed state motions for injunctions against this in their state courts, and they reached settlements with Defense Distributed, which is Cody Wilson's company. Those settlements basically meant that Cody Wilson would not distribute, through Defense Distributed, would not distribute any of the gun printing files to anyone outside of the United States. I think that was on there. They wouldn't distribute them to anyone in the state of New Jersey, and because of the nature of mobile devices, allowing poor, vulnerable, hapless New Jerseyans who might accidentally download this vile, disgusting files, they had to disable any mobile connections to the website as well, so that no one in New Jersey could accidentally download a file that would kill them immediately. Because as Alyssa Milano has stated, this is downloadable death. And when someone says something like that, we only wish to increase their internet speed and wish them on their way. Jason Benaim says, this complaint looks like it was built from a parts kit. It does. It does. So yes, I don't, guys, I'm so annoyed with this that I don't even know if I'm actually being coherent in this introduction. So let me slow down for a minute. What? Am I loud? I'm too loud. I'm too loud. Too mad. Too much Alex Jones juice. I absolutely would download a car. Okay. So let me slow down and pause. So they agreed not to distribute to the state of New Jersey, and I believe outside of the U.S. or any mobile connections through Defense Distributed. Then several attorneys general have filed a motion in district court in Seattle. Notice where they went. They went straight to the heart of cuckoldry, that is the 9th District, or the 9th Circuit. Sorry, not the 9th District. The 9th Circuit Court. And they found a giant idiot of a judge to issue a temporary restraining order to restrain the whole earth. Again, to restrain the lawful distribution of these files to United States citizens. Because if you don't know the background of this, it's not illegal for them to distribute these files in the U.S. This is part of something called the ITAR. Hold on, I'm going to make sure I get the acronym right. The International Traffic in Arms Regulations. Notice the operative word in that sentence. International. It's the International Traffic in Arms Regulations. It is perfectly legal to distribute these to United States citizens. But according to, and as we'll see in this ridiculous TRO, according to the website Defense Distributed, their mission statement is a global accessibility to the materials to make 3D printed guns. That's their mission statement. So because of that mission statement, the court has issued a restraining order restraining the lawful stateside distribution of these in the fear that, get this, someone in a foreign country might download the CAD files and print their own guns and create unrest. Where would that happen? Oh, I don't know. Maybe like Nigeria or Nicaragua or Afghanistan or anywhere where they have access to countless stockpiles of fully automatic weapons that they have constant civil wars with. But no, they're going to 3D print guns in these nations. Like that's honestly the complaint, is that someone will 3D print a gun, an expensive, pretty unreliable, ultimately, process that is not undetectable because they have metal bullets, you idiots, and they also have metal firing pins, you dummies. They can't just make a plastic gun that shoots murder plastic at people. It doesn't work that way. You think they mean in the EU. I don't think they mean in the EU, but you can argue, you can think that all you want. I really don't think that they're concerned that someone in Sweden is going to download a 3D printing file and then 3D print a gun. But I am going to go through this. Let me take a pause. There are a lot of documents already in this case, and I would like to go through them at some point, but if I do it now, it will take days. Let's see. The complaint, for example, is 189 pages. The motion for the temporary restraining order, 36 pages. Motion opposed to the temporary restraining order from the government, because yes, even the State Department is opposed to this, is 19 pages. And the motion opposed from Cody Wilson is 71 pages. So I'm not going to live stream through like 400 pages of legal documents right now. I'm going to just go through the restraining order itself, and at some point we'll do the background. But this will be enough to illustrate how ridiculous this is. If you can afford, yeah. Pseudo Meme says if you can afford a $3,000 3D printer, you can afford a real ghost gun. Mega Monster 1234. I assume this will get overturned quickly. I hope so. They have oral argument on August 10th for this currently, unless it gets continued out. So we should hear on August 10th. That's where this temporary restraining order is good until then. But what was I looking for here? I don't even know. Let's just start going through this order. Oh, I was going to look. Never mind. How is 3D printing a gun in Albonia even remotely within the purview of the state of Washington? Explain to me real slow. Sorry for repost. Okay. So yeah, right before going into the documents, let me explain the reasoning. ITAR is a Cold War era piece of legislation, and it exists basically to prevent materials from leaving the United States that could cause harm in other countries. It has been used to restrict just about everything from being exported from the United States. It restricts things in advance, and then they get removed as it's pointed out how ridiculous they are. So that's kind of how it works. If you talk to computer programmers who have been around enough, I guess like textbooks with encryption code and stuff like that in them were banned prior to this. I think, various computers, even video game systems, I think PlayStation 3s, like when they came out, they were banned because if you sent them to certain countries from the United States, they would be better than like the computing devices in those countries, and it could be used to do something. I don't know, pilot a nuke or something ridiculous. It's been used in that way for a long time. It's really legislation that needs to go because it does make the United States into even more of the global police. But the theory behind the regulations are that that if the U.S. were to release information that would destabilize a foreign nation, then it would be bad for U.S. foreign relations. Okay? That's the idea. So if we sent out some document that allowed an insurgency in India to rise up and overthrow a legitimate government, then that would be the U.S.'s fault, I guess. Never mind the fact that there might be reasons for an insurgency to overthrow the Indian government or whatever. But that's the theory behind it, is we don't want to be responsible for that. We only want to be responsible for that when we actually pay the CIA to go into these countries and do it. We don't want them doing it on their own, because if they do it on their own, they'll screw it up, right? And we won't get to spend $1 trillion and occupy it with our soldiers for the next 30 years. Ian Sterling says, greetings from Belgium. Ninth Circuit is really the epicenter of judicial activism, isn't it? Yes. Yes. And John Conley, you only think ITAR is currently under review because guess what? Guess what? This court order temporarily enjoins the State Department from its decisions on ITAR. Believe it, that's what this judge has done. This is the most frustrating thing I can think of. Oh, let's get into it. Let's get into it. Before I pop a blood vessel, I need some McWhiskey. Let's see. What do we got? How much freedom do I have? We're going with... Sorry, I gotta reach up high. Butt shot. Just for you guys. Peg leg porker. I can't drink all of this because Lady Rackets has not had a try on it yet. Your law professors love judicial activism? That's disgusting. Yeah, quite literally top shelf liquor. Thank you, YouTube is gay. This place bottles their own whiskey. This is great, by the way, if you get a chance. But they do it in wine bottles because I guess that's probably how you do it if you don't have your own, like, 100-year-old bottling company. All right. Hold on just a second. I need some inspiration. Okay. This is 7 pages. So this shouldn't take more than 2-3 hours. This matter comes before the court on plaintiff's emergency motion for temporary restraining order with notice to adverse party and defendants' oppositions thereto. So, this is State of Washington et al. Versus the United States Department of State et al. Let's see who it actually is from. Just so you know, if your Attorney General is a giant cuck. And to the Attorneys General who signed this document, I've called each one of them out individually on Twitter. And in addition to my Twitter challenge, for them to come on this show and justify to the American people what they've done, I also challenge them to a fist fight in person. Because this is the internet, and we need more internet tough guys, and I will fist fight any of these pencil-necked idiots any day of the week. I don't even need to train for it, because I've seen them. I'm pretty sure their Osteoplex vitamin supplements won't save them. Yes, an in-person fist fight. Absolutely. And I don't think challenging another attorney to a reasonable, gentlemanly fist fight is against the code of ethics. But if it is, then I mean it completely as satire. Freedom of printing 3D guns doesn't mean freedom from consequences. Seymour Scrotum, you're about to. All right, so this is the state of Washington, the state of Connecticut, the state of Maryland, the state of New Jersey, the state of New York. Are you surprised by any of these? State of Oregon, Commonwealth of Massachusetts, Commonwealth of Pennsylvania, and the District of Columbia. And if your state is listed, you might live in a limp-wristed communist wasteland, and you should consider moving out. The only thing I'm surprised is that Minnesota and Lori Swanson, the Attorney General of Minnesota, is not on this lawsuit. She has signed on to the letter with 21, yes, the 21 attorneys general. These are the highest law enforcement officers in their state. Literally wrote a letter to the manager. Guys, how much better? How much whiter soccer mom can we get than that? But they did that. Nicholas Melchiori says, I refuse to believe you weren't going to live stream based on how angry you are. Believe what you will, my friend. I'm surprised California isn't in it. No. Yeah, me too, frankly. Hashtag me too. I'm surprised California's not in it. Spookmeyer says, listen, Rackets, you're an American. Make like a freedom-loving founding father and challenge these cucks to a duel on the White House lawn. I'll use my 3D printed gun and they can use their 3D printed Rees and we'll see who wins. All right, so the defendants in this case are the United States Department of State, Michael R. Pompeo in his official capacity as Secretary of State, Directorate of Defense Trade Controls, Mike Miller, that's the position created by the ITAR, in his official capacity as acting... Oh, wait, Mike Miller in his official capacity as Acting Deputy Assistant Secretary of Defense Trade Controls, Sarah Heidema in her official capacity as Director of Policy, Office of Defense Trade Controls Policy, Defense Distributed, Second Amendment Foundation, Inc., and Con Williamson. I don't know who Con Williamson is. Yeah, and Trump's tweet should worry you. And guys, if you are Trump fans, and if you think I'm a Trump fan, I'm not. I think a lot of his actions are constitutional and I defend them. I'm not a big fan of his. I'm not a fan of Hillary by any stretch. And I'm glad that we have him instead of her. But if you have to, like, if you don't know, right? Trump is a nationalist, pseudo-authoritarian. He's a protectionist. And this is absolutely not something that a traditional nationalist authoritarian likes. They don't like 3D printed guns. They love regulation. They love things like registries and lists. And the NRA isn't here to help either. The NRA has fully cucked on this. And at the moment, I'm putting Trump in that category. We'll see what he does. But his tweet, let me, again, I can't express enough how pissed off I am at these people for this stuff. Let me just go ahead. I got to pull up a document. Here. Bear with me. I had forgotten. I wasn't even going to bring it up. But these attorney generals filed an emergency letter today. Was this it? No, this one wasn't it. Where was it? Here? Just a second. Burning money as we talk. Here we go. I'm going to pull this document up. Look, and if you, again, doesn't matter if you love Trump or not, be pissed off at Trump for this. Notice the filing. So this was filed today. An emergency filing. Plaintiff states submit the attached declaration of Todd Bowers in support of their emergency motion for temporary restraining order. Mr. Bowers' declaration attaches a public statement made by President Donald Trump on his personal Twitter account at 5:03 a.m. on July 31st. The statement is relevant to the state's argument that defendants made a temporary modification of the United States Munitions List Category 1 so as to exclude the computer code files at issue in this action without proper notice, as required by 22 U.S.C. Section 2778 F1, Executive Order 13637, Section 1. The states may refer to President Trump's statement at oral argument in support of their motion. Does anybody think that that's what Trump's tweet right here meant? Does anybody think that Trump, who issued the freaking executive order, he issued the order that they referenced just then that said that we should change course on this, but they're saying that because he tweeted this, that he's questioning his own executive order and he's questioning the settlement that the State Department reached with Cody Wilson. That's what they claim. And that's the danger. This is part of the danger of Trump and his tweets. Look, I don't begrudge the man tweeting. I think he's hilarious on Twitter, and he really makes people like my dad mad, which is funny to me. That's fine. That's fine. And sometimes he says things that are really idiotic. But sometimes those idiotic things end up with bad policy, and I don't know how much it affected the judge's decision, but the fact that they have a statement from Trump in support of people who he probably hates is really, really freaking irritating. Lady Rackets, don't tick me off. You go to sleep. Anyway. He doesn't have freedom from consequences. All right, I promise I'm going to get to this document. I just keep getting annoyed. I can't help it. I got a problem. All right. So back to it. On or about June 29th, 2018, defendants entered into an agreement whereby the federal government agreed to publish a notice of proposed rulemaking and final rule revising the United States munitions list to allow the distribution of computer-aided design files for the automated production of 3D printed weapons. to announce a temporary modification of the USML to allow such distribution while the final rule is in development, and to issue a letter to Defense Distributed and other defendants advising that the CAD files are approved for public release and unlimited distribution. If you didn't catch that, the government has promised to change the rules in a binding legal settlement. They promised. They promised to do it. And we're operating under that thing. So Cody Wilson has been operating under the assumption since June 29th, for over a month now, that he would be allowed to publish these files, that he is allowed to publish these files because the United States has specifically stated that it will change the rules and make it happen. I don't know if Trump's reputation as a flip-flopper should be a defense too. I don't know. I don't know. I really wish that tweet wasn't used here. It's used improperly because I really don't think Trump is questioning his own executive order. Really don't think that's happening. Okay. All right. The agreement was made public on July 10th, 2018, and Defense Distributed is currently allowing individuals to sign up to download specific CAD files on August 1st, 2018. Prior to June 29th, 2018 agreement, the federal government had taken the position that restrictions on the export of technical data that is indispensable to the creation of guns and their components through a 3D printing process was an essential part of its efforts to ensure that articles useful for warfare or terrorism do not proliferate and threaten United States interests and security. So, downloading feet pics, I think. You said you thought that this applied to Europe. I don't think that the Obama administration was concerned that Europe was a source of terroristic threats. But maybe they were. I mean, despite them prosecuting a war in Afghanistan and Iraq for basically the entirety of Obama's presidency. But here we go. Again, it's expensive, unreliable, not durable. It's much easier if you're a terrorist organization to just get fully automatic AK-47s. And the evidence of that is every live leak video you've ever watched of terrorists with AK-47s. Like, they have them. They don't need to 3D print them. It would be a waste of time and resources. And you know what? If terrorists were downloading these documents, you could trace them. You could find them. So they're not going to do it. All right. Under the Arms Export Control Act, the President of the United States is authorized to control the import and the export of defense articles and defense services. In furtherance of world peace and the security of the foreign policy of the United States, defense articles and defense services include all firearms up to .50 caliber and all technical data related to such firearms, including information that, quote, is required for the design, development, production, manufacture, assembly, operation, repair, testing, maintenance, or modification of the firearms. Because apparently other countries don't know how to make them. No one's figured it out. I'd just like to interject for a moment. What you're referring to as an AK-47 is in fact an AKM, or as I've recently taken to call it, a modernized AK. Well, thank you. I mean it in the colloquial sense of the fully automatic Kalashnikov rifle that is emblematic of Middle Eastern terroristic regimes. Hey, thanks, Colin Lorenzo. I appreciate that. Yeah, up to 50 cal, so larger is apparently okay. Yeah, that apparently is correct. I don't actually know if larger is actually okay. It might be. It might not be. It might be a separate regulation, but that's what they say. All right. When Defendant Defense Distributed posted CAD files for various weapons on its website in December 2012, the federal government requested that they be immediately removed from public access. The government advised Defense Distributed that it could request a determination from the Directorate of Defense Trade Controls within the United States Department of State regarding whether the files were subject to export control under the International Traffic in Arms Regulations. So, footnote. The president delegated his authority to regulate under the AECA to the State Department, which promulgated the ITAR. The DDTC administers the ITAR. Defense Distributed filed a number of determination requests. It also filed a lawsuit in the United States District Court for the Western District of Texas in which it argued that the export restrictions constituted a prior restraint and censorship of expression in violation of the First, Second, and Fifth Amendments to the United States Constitution. That's from Defense Distributed versus U.S. Department of State. Good night, Lady Rackets. I won't die unless I have a heart attack from my blood pressure. I love you very much, and I will see you in the morning. Mega Monster 1234. Do you think the lawyers who will fight this will use the same arguments you're using? I've seen too many incompetent lawyers as of late. The guy fighting this seems to be very competent. He's very competent. And he does this. Like, this has been his job for years. He knows this argument better than anybody. I'm going to ask if he'll do an interview with me. I don't know if he will because he's probably horrendously busy. But this is a good time to announce that tomorrow I will be interviewing, what is the gentleman's name? Hold on. Stephen Gutowski from the Washington Free Beacon. He's a reporter who's been covering this issue. He was pretty active on Twitter today talking about all of the other journalists who have been getting this issue wrong. So we're going to talk about stuff like why journalists can't report properly on Second Amendment or legal issues and stuff like that. Should be a good interview, and I will post it. It will not be live streamed, but I will post it as soon as possible. So that's going to happen as well. Remember that time a kid spent 4 weeks 3D printing a gun using a loud printer and no one noticed, and he brought it to school and killed 40 people because he trained on video games? No. Did that happen? I don't think so. Okay. Defense Distributed sought a preliminary injunction. Mega Monster, I'll answer that a little bit later. Okay. Defense Distributed sought a preliminary injunction precluding the imposition of any pre-publication approval requirement for its CAD files. The federal government opposed the motion, arguing that... Now, notice what they're doing here. They're using arguments from 2012 for a motion that was settled by the parties in which the government has gone the opposite direction from these arguments just this year. They changed everything. They changed all of this stuff and said, no. So they're using the original argument that the government no longer agrees with. We'll see, Andrew. We'll see. Okay, so the arguments are export of Defense Distributed's CAD files could cause serious harm to U.S. national security and foreign policy interests and warrant subjecting the files to ITAR's export licensing of technical data. Next bullet point, Defense Distributed's CAD files constitute the functional equivalent of defense articles capable in the hands of anyone who possesses commercially available 3D printing equipment of automatically, it's even in quotes in their own stupid argument, generating a lethal firearm that can be easily modified to be virtually undetectable in metal detectors and other security equipment. Sure, I guess, except no. Like, if you make it undetectable, it then doesn't function. And if it's undetectable because you don't have bullets, then it still doesn't function. It'd be just like a club, a 3D printed bludgeon. No, automatically is a quote within a quote. If you notice, there is a single apostrophe, not a full quotation mark around it. It is a use that they're acknowledging that it's not automatic, that they can print the pieces and put it together, but they're saying it in a persuasive manner, but they know they can't get away with it being automatic because the 3D printing machine doesn't assemble your gun for you. It prints individual pieces, and you have to assemble all of them. Welcome, Ben Cheevers. Welcome. My ghost gun shoots ghost bullets. Completely untraceable. It just gives you a heart attack. Okay. The State Department, this is the next bullet point. The State Department is particularly concerned that Defense Distributed's proposed export of undetectable firearms technology could be used in an assassination. Because no one's assassinated anyone before this using just a good old regular gun or a knife or like a plastic bag or anything like that. For the manufacture of spare parts by embargoed nations, terrorist groups, or guerrilla groups, or to compromise aviation security overseas in a manner specifically directed at U.S. persons. Again, unless you've got the bullets, the gun being undetectable doesn't help you. And notice no one's done this. You could have done this in 2012, 13, 14, 15, 16, 17, and 18. And it's only gotten actually easier every year because anybody who can operate a CAD program and does technical designs can actually design every single part. They can do it. They don't even need the defense distributed stuff. Trust me, someone in another country could reverse manufacture the components of a firearm and do this. And they don't. Why? It's expensive. It's cumbersome. And they can get a gun anywhere else. Easily. All right. Both the government and the public, quote, have a strong interest in curbing violent regional conflicts elsewhere in the world, especially when such conflict implicates the security of the United States and the world as a whole. That's a laugh. I'm sorry. That is a freaking laugh. Oh my gosh. The then director of the Office of Defense Trade Controls Management, Lisa Aguirre, concluded that the unrestricted export of Defense Distributed's CAD files would result in the production of plastic firearms that are fully operational and virtually undetectable by conventional security measures. So again, notice how this is worded. Lisa Aguirre concluded, based on what? Was it a study? Did she 3D print a gun? What? She just concluded it. Because the Obama administration appointed her and then issued a directive to go after Cody Wilson. This had nothing to do with a conclusion that was logically reached, reasonably reached, legally researched. They just decided that this thing, virtually undetectable by conventional security measures. But again, if it's undetectable by conventional security measures, you've removed the functionality that makes it lethal. That they're used to commit terrorism, piracy, assassinations, or other serious crimes that cause serious and long-lasting harm to foreign policy and national security interests of the United States. That may be true, except they aren't used in this way. That efforts to restrict the availability of defense articles to enemies of the United States would fail. Oh, you're doing a bang-up job. You frickin' sell this stuff to them. This is the Obama administration. This is the administration of Fast and Furious. These guys literally sold illegally firearms to cartels in Mexico that were then used to kill U.S. border agents and U.S. citizens. And they've traced the frickin' guns back to the program implemented by the Obama regime. These guys are international arms traffic dealers telling a guy who internationally arms trafficked 0 firearms that he's the bad guy. It's absurd. Arrgh! Okay. And also, all of their enemies have all the guns they need. All that they need. Have we ever gone in to an insurgent situation or a terrorist situation or a nation state that is oppressing its people and found that they didn't have a sufficient amount of firearms? Like, have we ever, you know what? We got to Kuwait and they didn't have any guns. The Iraqi oppressing army, they didn't have any guns. No. Of course they had guns. Oh, we got into Afghanistan. We found out ISIS didn't have any guns. Weird. They were throwing rocks and using bow and arrows that they constructed out of balsa wood. No, obviously, they have plenty of firearms. An abundance of firearms are available because they don't just get them from the US. And a 3D printed gun is an inferior product to what is comically easy to obtain by any of these dangerous people. I can buy a knockoff G3 for $300 online, or I can buy a $500 3D printer, $200 in plastic, and spend hours fixing pieces that don't fit exactly as a terrorist. I'll go with option B. Exactly, Tillip. Exactly. This is absolutely ridiculous. Oh my gosh. And that the export would undercut the domestic laws of nations that have more restrictive firearm control and the United States' foreign relation with those nations. It would suffer. Sorry. Would suffer. I left that out. This whole thing reminds me of Puckett guns, where the British man made submachine guns with parts he bought at a hardware store to prove you can't ban the knowledge. The district court denied the motion for preliminary injunction, noting that Defense Distributed's avowed purpose is to facilitate, quote, global access to and the collaborative production of information and knowledge related to the three-dimensional printing of arms, and that such activities, quote, undoubtedly increase the possibility of outbreak or escalation of conflict. Undoubtedly. Except there are 0. Find a single... Because I guarantee you it would be the biggest story of the day. Find a story where a 3D printed gun caused any escalation of conflict in any country. Find it. I'll wait. I'll wait. And are of the type Congress authorized the president to regulate through the AECA. The Fifth Circuit affirmed, finding that the State Department's stated interest in preventing foreign nationals, including all manner of enemies of this country, from obtaining technical data on how to produce weapons and weapons parts constitutes a very strong public interest in national defense and national security. In April 2018, the federal government moved to dismiss Defense Distributed's lawsuit, reiterating what was at stake was, quote, the United States' ability to control the export of weapons, a system of law and regulations that seeks to ensure that articles useful for warfare or terrorism are not shipped from the United States to other countries or otherwise provided to foreigners without authorization, where, beyond the reach of U.S. law, they could be used to threaten U.S. national security, U.S. foreign policy interests, or international peace and stability. Should questions of pragmatism even be paramount in judicial decisions over constitutionality? Drinking some Bruxellier in your honor. Bruxellier in your honor, buddy. No, Ian Sterling. They should not. They should not. This is a constitutional issue. The question should be, does the government have the power to restrict, to place a content-based prior restriction on speech in this case? I don't think they do at all. Okay. Let's see what happens next. Later that month, the parties reached a tentative settlement agreement which, as described in the first paragraph of this order, will allow Defense Distributed to place downloadable CAD files for automated weapons printing on its website. No findings of fact or other statements are provided in the agreement that could explain the federal government's dramatic change of position or that alter its prior analysis regarding the likely impacts of publication of the United States national security interests. That's because it was an agreement, a settlement. These judges act like they have no idea how the law works. When you're in court, when you're actually arguing, you argue the maximum argument 100%, because you don't give ground in court, because the judge is going to come somewhere in the middle on a lot of these cases. He's going to say, okay, well, here's your extreme argument and here's their extreme argument, but I found resolution kind of part for them, part for you, somewhere in the middle. We can work out this sort of arrangement. That's how civil cases work. Is like there's some give and take. So when you're in court, you're arguing the maximum. Behind closed doors in negotiations, you're offering up concessions. You're changing the nature of how you do things. I don't know, maybe Defense Distributed says, you know, we're not going to publish plans for fully automatic weapons because we know that fully automatic weapons can't be manufactured after 1986, and there's no reason for us to publish them. But all of these other weapons can legally be made by any schlub in his house. Like, this is legal stuff to do. So of course we're going to print these plans and we're going to make it easier for people to do it and spread knowledge. That's okay. But we're going to restrict, like, we're not going to publish anything with a fully automatic gun. They make a concession. And the State Department says, yeah, you know what? We don't want these getting out of the country, but maybe we could find a way so that you could try and ensure that only IP addresses within the United States are able to access these files, or only members from inside the United States who contribute money and join up to your campaign. They make concessions because when you're not in court, you have the flexibility of doing that. The judge acts like this is some foreign process to him. And maybe it is, and he should be impeached and thrown out. I don't know. It's insane. It's insane. Well, there's nothing could explain the dramatic shift. Except it might not have been a dramatic shift. But there is something obvious that could complain. Limp-wristed ladyman Obama is out of office. And now you have Trump, who has billed himself as pro-NRA and pro-Second Amendment and Republican. So he better come out strong on guns, right? So he comes in, and of course the feds changed task on this. Of course there's a dramatic shift. You've gone from a borderline socialist to a nationalist authoritarian. What? Like... authoritarian right, let me say. Like, of course there's a dramatic shift. Nothing could explain it, though. Oh, all of the leftist journalists crying the day after the election, crying on live TV like a bunch of babies. That couldn't explain. They can't explain that either. They don't know what happened. They just all cried collectively like a bunch of pansies. Because the country and world were going to end. That's how dramatic the difference is, you stupid judge. I gotta calm down. Just a minute. I know he's out against the 3D printed gun now. But he wasn't a month ago. All right. No findings of fact or other statements are provided in the agreement that could explain the federal government's dramatic change of position or that alter its prior analysis regarding the likely impacts of publication on the United States national security interests. Let me put a bracket in there and help you read between the paragraphs. The judge says, so I'm going to ignore the agreement. Right there. On July 30th, 2018, 2 days before Defense Distributed plans to place downloadable CAD files on its website, 8 states and the District of Columbia filed this lawsuit seeking a declaration that the temporary modification of the USML is invalid and an injunction requiring the federal defendants to rescind the procedurally defective modification and refrain from acting on it. So this is how they're attacking this. We finally get to it. And this is a justification. It's not that that Cody Wilson is being restrained. It's that the United States government, these 9 attorneys general, or 9 attorneys general have simply decided that the federal government's lawful agreement, their settlement agreement, shouldn't be enforced, and it was unlawful. That's what they've decided. Okay. All right. Having reviewed the papers submitted by the parties along with the record before the Honorable Robert L. Pittman in the United States District Court for the Western District of Texas, and having heard the arguments of counsel, the court finds as follows. And this is gonna... I'm gonna try and get through this without having an aneurysm, because there's real problems with this order. The procedure for obtaining a temporary restraining order differs from that which is applicable in the preliminary injunction context, but the factors considered by the court are the same. In order to obtain preliminary injunctive relief, plaintiffs must establish that 1, they are likely to succeed on the merits. These guys are not likely to succeed on the merits. They don't likely even have standing to bring the suit. 2, they are likely to suffer irreparable harm in the absence of preliminary relief. Pay attention. These are 9 attorneys general of states. And this is an international trade in arms regulation. International. Not within the states. Cody Wilson can take these drawings and CAD files. He can actually hand them out by disc to citizens of New Jersey, no matter what the idiotic attorney general wants to say. He can take a CD with all the CAD files on it and hand it to you, and it's legal. 1,000% legal. What he can't do is send it electronically to Iran. Okay? That's what's wrong. So these 9 attorneys generals are saying that they will suffer irreparable harm for their states in the absence of preliminary relief, preliminary relief of which should be to enjoin Cody Wilson from mailing it overseas. They can't suffer irreparable harm for constitutional activity. This judge is the dumbest person I've met today. And guys, that's high on the list because I used a telephone service and had to talk to poor idiots whose job it is to talk to me on a phone today. But this judge wins. 3, the balance of equities tips in their favor. In their favor. They don't even have standing. The law doesn't affect the distribution of this. Again, honestly, if Cody Wilson could guarantee that this would never leave the country, he could publish it all day. All day. And 4, an injunction is in the public interest. Remember, guys, this judge is about to find that it's in the public interest to have their rights to free speech and rights to firearms and their 5th Amendment due process rights suppressed and stamped out. That's what they're going to find. I'm throwing shade at that answering service because they deserved it. All right. But listen to this. Listen to this. And I'm going to say it as he wrote it. In the Ninth Circuit, if a plaintiff can only show that there are serious questions going to the merits, a lesser showing than likelihood of success on the merits, then a preliminary injunction may still issue if the balance of hardships tips sharply in the plaintiff's favor and the other 2 winter factors are satisfied. Do you hear this? So this judge knows that they're not likely to succeed on the merits. But there's an extra rule that if they add an adjective to the tipping of hardships, that suddenly they don't need to show that they're going to succeed on the merits. Now we can have a temporary injunction just because. Just because. Yeah, the judge's name is in the document, and you can shame him specifically. It's at the bottom. We'll get there. Plaintiffs have shown a likelihood of success on the merits of their Administrative Procedure Act claim insofar as the temporary modification has resulted in the removal of one or more items from the USML. Footnote 2. Here we go. I don't know if I'm going to make it. For purposes of this temporary order, the court finds that plaintiffs have standing to pursue their claims. Notice, they haven't found standing for the complaint yet, just for this temporary order. And even this is wrong because look for the argument for standing that state attorneys generals and the District of Columbia's attorney general would have anything to do with an international publication. You look for the argument in this footnote. Although the restriction of access to technical data within the United States is not the focus or goal of the USML, no, Judge, it's specifically outside the purview of the USML. It has nothing to do with the USML. There is no separation of the internet between domestic and international audiences. I mean, there is. Ask China or North Korea how the internet works with international audiences. There's no separation. They can just, restrict whatever website they want within the bounds of their countries, but there's no separation. Thus, the listing has effectively limited access to the CAD files within the jurisdictions governed by the plaintiffs. Keck7 Go, read it in Elmo and Clinton voices. Not tonight, man. I'm too angry. The states and the District of Columbia have a clear and reasonable fear that the proliferation of untraceable, undetectable weapons will enable convicted felons, domestic abusers, the mentally ill, and others who should not have access to the firearms to acquire and use them. But here's the kicker, folks. That's nothing to do with ITAR. That has nothing to do with it. Because convicted felons, domestic abusers, the mentally ill, and others who should not have access to firearms to acquire and use them could go buy an 80% lower receiver, they can violate federal law, and they can mill out the parts to make it a fully functional firearm. And they would be violating federal law, and they would go to prison if anyone found out. They can still do that. They can still do it. All right. Back to the beginning. Not to the beginning. Back to following the footnote. The federal government represents that its settlement was the result of a multi-year review process, which was completed in May 2018 and resulted in a determination that the type of firearms and related technical data at issue here would not provide a military advantage to adversaries. Oh my God! Let's see. A 7-shot AR-15 lower receiver that will literally break after 7 to 15 rounds have run through it. Like, that won't provide a military advantage over just having a fully automatic AR or AK or just about any other weapon that they could possibly want because they're all over the place. Or even a hunting rifle that can run more than 7 to 15 rounds through it before you break it and costs less. Or even a shotgun. Or anything like a club with a nail in it. Sorry. Would not provide a military advantage to adversaries and therefore no longer warrant export control under the AECA and should be removed from the USML. Which, remember, Congress gave the the authority to the president, who delegated it to these people to deal with. In such circumstances, the governing statute, 22 U.S.C. 2778 F1, requires that the results of such reviews be reported to Congress and precludes the removal of any item from the USML until 30 days after such notice is given. That's fine. That's still within the settlement. When the president delegated his authority under the AECA to the Secretary of State, he also imposed a requirement that any changes in designations of defense articles and defense services subject to export control had to have the concurrence of the Secretary of Defense. There's no indication that the federal government followed the prescribed procedures. Again, that's fine that they haven't done it because they haven't provided notice to Congress yet, so the 30-day change hasn't taken place. All they've done is promised not to enforce until the rule change is made. Don't forget the potato peelers in the UK. Is it possible that the U.S. military has created a 3D printed gun that actually is a military advantage that will not disclose that fact? No, I don't think so. Because there's no reason for them to do that. Like, there's no reason for the U.S. military to create a 3D printed gun. If they did, it would be using a very expensive 3D printer that printed a metal gun. Plaintiffs have also shown a likelihood of irreparable injury if the downloadable CAD files are posted tomorrow as promised. No, there's no injury because they can post them and anybody in the state of New Jersey can download them and there will be zero injury because this is constitutionally protected activity. You can't have an injury because there's no violation of law in doing that. Even a felon could download this stuff. They just can't have the gun. A side effect of the USML has been to make it more difficult to locate and download instructions for the manufacture of plastic firearms. If an injunction is... That's a side effect. Lots of side effects occur. Those don't carry the force of law. If an injunction is not issued and the status quo alters at midnight tonight, the proliferation of these firearms will have many of the negative impacts on a state level that the federal government once feared on the international stage. Once feared until they thought about it for 10 whole seconds without being ordered by a communist to oppose it. And they went, you know what? There's no sense in anyone making these guns other than hobbyists. There's no sense for a terrorist or a would-be assassin or anyone to make an unreliable gun. Because if you're going to just murder a head of state somewhere, you'd probably just do it with a regular, reliable firearm. And it still rarely ever happens. Against this hardship is a delay in lifting regulatory restrictions to which Defense Distributed has been subject for over 5 years. So just because their rights have been infringed for 5 freaking years, we can just keep it going. That's fine. The balance of hardships and the public interest tips sharply in plaintiff's favor. For all of the foregoing reasons, plaintiff's motion for temporary restraining order is granted. Federal government defendants and all of their respective officers, agents, and employees are hereby enjoined from implementing or enforcing the temporary modification of Category 1 of the United States Munitions List. This judge is ordering them to prosecute a case that they have settled. A judge without respect for the judicial system should be impeached and removed. And the letter to Cody R. Wilson, Defense Distributed and Second Amendment Foundation issued by the U.S. Department of State. Issued by the freaking Department of State! And shall preserve the status quo ex ante as if the modification had not occurred and the letter had not been issued. This judge just ordered the U.S. Department of State to bring civil and criminal charges against someone. I mean, it's a mind-blowing. This is some cuck in the middle of Washington State. Robert Lasnik. Let's just do a Wikipedia on him. Let's just guess. All right. Judge of the United States Court for the Western District of Washington. Appointed by Bill Clinton. I thought he was going to be a Reagan appointee. Color me shocked. Pursuant to the limitations set forth in Federal Rule Civil Procedure 65, this matter is hereby set for hearing on Friday, August 10th, 2018 at 9 a.m. in courtroom 15106 to determine whether this temporary restraining order should be converted to a preliminary injunction. No bond shall be required, except for the bondage on you, baby. There you go, guys. That's a TRO. If the president has the power to control what is under the jurisdiction of ITAR, can't he at any time just remove CAD files from the restrictions? In a roundabout way. In a roundabout way, yeah. But he delegated his authority, so they have to do it. But apparently you need a letter. Let's see. With concurrence of SecDef. So we don't know if Mad Dog Mattis, the SecDef, will approve this. I guess he hasn't concurred. Oh, John Russell, that'd be magical. Just record it. Bill Clinton is the better of the two because while he plays the sax, his wife plays the people. Now we need Elmo. Oh my goodness. Let's see. Let's see if I can do this for you guys. Oh my gosh, can I get a decent resolution picture of this idiot? No. Here we go. Look. Imagine my shock that that guy's opposed to 3D printed guns. Zarther says, how double jeopardy doesn't enter into this. Let me think. Well, okay, so what he's done is he's basically undone the settlement. He revoked it ex ante, so it goes on as if the settlement had never occurred and the letter had not been issued. So it's not double jeopardy, it's still ongoing. What about that guy would suggest that he'd be opposed to 3D printed guns? Well, for one, he doesn't have a 3D printer. He's got a regular printer. For two, look at this face. Ugh. I don't know. But look, does that guy look like a guy who's going to 3D print a gun and go shoot it? Does that guy look like a guy who's ever shot a gun in his life? Ugh. I looked him up just so I wouldn't end up challenging Judge Dredd to a fist fight. Most of the guy's mass comes from his jacket. I don't just look at how this picture's awful. This judge is appointed. State judges are typically elected. Hey, Tilipa, I'm not picking on anybody with a messy office. Speedy trials are criminal cases, and speedy is subjective. The complaint that they filed was actually their own. It was a civil case against the United States government. So no, they don't have a right to a speedy trial here. If Cody were brought up on criminal charges, that would be a speedy trial issue. Yeah, he apparently has appointed a lot of good constitutionalist judges. We'll see, of course. We'll see in 10 years when they're making weird decisions and I'm like much older and I'm like, oh, figures, Trump appointed him. And look at this. Okay. I undid it, didn't I? Sorry. I don't know. I'm going to not make fun of Robert Lasnik anymore because I can't take it. I can't take it. He overlooks serious issues with this. Like the standing of states to even bring this case. What interest is there? It's constitutionally protected activity inside the U.S. It's only leaving the U.S. that it's unprotected. I'm not drinking anymore tonight. I've got to save up for Atlanta, guys. I actually, I'm going to call the stream to a close because I don't want this to drag on. I want this to be at least somewhat digestible. It's an hour and 12 minutes right now. So I'm going to cut it off within the next 3 minutes. But, yeah. So thank you guys. Thank you, of course, for watching this. You know, if you like this, I hate doing this, but share it around, throw it up on Twitter, whatever. I appreciate, of course, all of the support. I can't wait to see some of you guys in Atlanta. Tomorrow, like I said, interview with the guy from Washington Free Beacon. It will not be live. Stephen Gutowski. I will post it as soon as I get approval to go through it. Bradford Walker, yeah, pretty much. That's the TLDR. So definitely check out the video tomorrow. It should be a good interview. The guy seems pretty interesting. Oh yeah, quick opinion on textualism versus originalism. I'm more of an originalist than a textualist. I don't really like the textual approach. Clarence Thomas is more of a textualist. Scalia is more of an originalist. Alito is more of an originalist. Although they have their flaws and failings on those accounts when it kind of suits their argument. But the Constitution was passed and the founders had an idea of freedom. I really don't think we should mess with that because they gave us an amendment process that allows us to change the Constitution at any time. I believe most of the founders figured that the Constitution would be dramatically changed within 30 years of its passage and adoption. So we should be doing that. We haven't done it because of things like that, of judicial activism. That's why we don't change the Constitution. That's why we have a 200 and however many year old document rather than a document that updates as we go, is because we expect judges to do it for us. Gorsuch, I don't know. I haven't read enough of his opinions. I don't really research a lot of these judges because it's awful to do, but we'll see how he turns out, you know, as he keeps rendering decisions. So we'll get an idea what his judicial perspective is. Anyway, thank you guys so much. I have 30 seconds to end this stream and go calm down and then go to bed. Yes, if you are a patreon.com lawsplaining subscriber, remember tomorrow is Wednesday. or today, I guess later today is Wednesday, and there will be a live chat. So definitely join up for that. If you're interested in that, the $5 level and up has access to the Discord server. You could certainly subscribe tonight and get access to it tomorrow. Join us for the conversation. And stay tuned for Rekieta Law School. I am working out details on that, and it will be actual graduate level classes minus the tests, minus the accreditation. So you won't be able to use this as credits in any sort of thing. But, you know, you also are just going to get an actual law class. We're going to do constitutional law. We'll eventually be doing criminal law, family law, all of this stuff, like real courses, real cases, real textbook basis for all of this stuff. And it should be a great experience. So follow that. It will be Patreon exclusive, and there will be tiers of it. You know, it's not going to be just $20 patrons, although they will get the most access to it. But, you know, and I will bring in guest lecturers and stuff like that. It's going to be cool. I really want to find a way to engage people on Patreon in a cool, meaningful way that they can get a lot of value out of. And I think that's a great way to do it. So stay tuned for that. We will see you all later. Thank you so much. And see y'all in Atlanta. I will find a way to live stream from there and see some of you in person. Anyway, I'm going to stop streaming. Ha! Talk to y'all later. Peace.